Welcome, viewers, to this episode of podcast. I am Tripti Vini, a senior partner with Hammurabi and Solomon. I handle the corporate function over here, and today we are going to unpack the most significant legislation of the decade, which is implementation of the new labor codes. We have on this panel today one special guest with us. He is the ex-deputy commissioner, ex-deputy chief of Labour Commissioner. He served the government for a number of years on this particular subject. We also have Mr. Anil Tiwari, who is a senior partner with Hammurabi and Solomon, with good 15 years of experience in this particular subject. And we also have Nayan Mittal, who is part of the core function of the compliance team at Hammurabi and Solomon. Over to you, sir. We would like to hear a little more from you.
Code on wages has been introduced. It was very important topic which was in news since last more than 5 years, that the government is going to introduce the code on various labor codes. And finally, it was passed in the year 2020, but implemented in the year 2025. So, out of 4 codes, today in this episode we will discuss the our discussion will be confined to the code on wages, and then I will discuss the important features of the code on wages, which starts with the removal of the scheduled employment. Scheduled employment is a category of workers which was earlier under the Minimum Wages Act, for which the government fixes the appropriate government fixes the minimum wages for them. The reason that why there was some difficulty which was faced by many of the workers, because their name or their category of employment was not incorporated in the scheduled employment, and that's why the government has decided that the scheduled employment should be removed. So it is the universal applicability, now the uniformization, uniform application of the minimum wages to all category of workers on the basis of their nature of employment, like unskilled, skilled, semi-skilled, and skilled. So the first and foremost important feature which has been introduced, that the government has decided to remove the concept of scheduled employment, and on the basis of this, all the state government which have their own scheduled employment list will also be removed. Another feature which was introduced in this code on wages, that is to remove the threshold limit, that is earlier for the employed person who are getting up to the rupees 24,000 rupees per month, where only the person eligible to get any relief under the Payment of Wages Act. Say for example, if there is any unauthorized deduction to any employed person, so if their salary is more than 24,000, they were debarred of any kind of relief under the Payment of Wages Act. So by removing this threshold limit of 24,000, the government has decided the applicability of the codes on all the category of employees under the code, which is the second most important feature of this code. Third is the introduction of the new concept of the floor wages. Floor wages is kind of guidelines which the central government will issue for the states government, that whenever they are fixing the minimum wages, they should take into account this the amount which has been fixed as a floor wages, and no minimum wages to be fixed by any state should go below this level. This is because of the action which was taken by government to introduce this concept of floor wages was for decreasing the disparity between the states, and also to cover the minimum standard of living to all the workers, that it should cover all their basic needs by their minimum wages. Means their minimum wages should be in a position to cater the basic needs of a employee and his family. Fourth, the most important feature of this code is the same and similar wages. Although the concept was not new, earlier the concept of same and similar wages was only confined to the Equal Remuneration Act, where the gender biased, which was the objective of the Equal Remuneration Act, was to check that no male and female employees who are working in the similar category can should be discriminated. Means their salary should be, or their wages should be at par. So now this is not confined to the male and female, rather it is confined, it has been open for all the employees who are discharging the same and similar work, even though they are working as a temporary worker or daily wager or the contractual worker or the fixed term employee or the employee of a contractor. The if they are discharging the similar nature of work, their wages shall be at par with. Then the role of inspector cum facilitator has also been increased. Earlier, he was only responsible for the implementation of the labor law, that is to ensure that the establishments are doing the compliance of the provisions of the labor law. But now his advisory role has also been incorporated into it. Means all the inspector will now assist the employers how to comply the provisions of the labor law, as well as all the employers has been made liable that all the information which is relating to their establishment, which is relating to the unauthorized deduction or any kind of deduction from the salary of the worker, should be informed to the inspector cum facilitator, so that he should ensure that there is no any discriminative action taken by the employer. So not only the role as a prosecutor, rather he has been friendly to the employer as well as the workers who can treat him as a friend, that in case of any problem they can approach to the inspector. And last but not least, we can say that the principal employer has also been made responsible to ensure that the payment of wages to all the contract laborers should be made by 7th of the next month. Otherwise they can take the action and disburse the wages to all the workers of the contractor, and shall deduct the payment from the bill of the contractor. So earlier the similar provision was there, but change was that until unless there is any complaint which has been received by the principal employer, the action by the principal employer could not be initiated. But now this is the suo motu responsibility of the principal employer to see that whether the wages has been paid to the contract labor, and if it is not there, they can, without any complaint, they initiate the action for the ensuring the payment. So these are the broader features of the new code on wages, and I think we will continue in the similar episodes in the future also. Now my second
I will say first thank you. Thank you, sir. That was so nicely put. And there's quite a bit of it there over there, but I understand the new legislation has only brought clarity into what was not there earlier. So thank you so much for your
uh, Tripti man, My question is next question is relating to what would be the role of the GC and other council of the organization to comply the provisions of the new labor code. I will. I want that it should be explained briefly that the role of the
New general
new
councils.
general council.
Thank you, sir, for that question. And frankly, the general councils are a new breed altogether, and nothing has much changed for them. I would say the compliance architecture would remain the same. Earlier, also the way the compliances was done is how it will be done now. Also, it's just that the compliance framework hasn't changed, but the compliance positions have changed, certain interpretations have changed. We would say that any general counsel in any legal team has a compliance framework where they usually put the issues or the compliances into three buckets. The minimum risk bucket, wherein it can be addressed by minimum, not really putting the business intervention being there, and it can be easily addressed where uh, the audit can be visited every 4 or 5 months. Then there are medium risk areas wherein, yes, a little bit of more focus is required. And it is true for all compliances, not just this new labor code that has come in place. An audit, I think, around 2 to 3 months is what usually is invested by general counsels in a medium risk, any medium risk compliance area. Yes, the high risk zone is where the focus is for all general counsels. These are compliances where there can be a criminal liability, or there can be a high penalty on the company, or the directors can be, impleaded in certain matters, certain cases, or there is a possibility that the reputation of the company is at risk. Those are the areas where usually the general counsels focus a lot, and they structure the architecture of a compliance in any company such that these are revisited every month or earlier if required. And if there is a red flag, it goes to the right stakeholders and it gets addressed. So, from a compliance, I would say, perspective, how this new labor code is going to impact the whole architecture, I don't think there's much that will change in terms of risk allocation and the way it will be audited. Yes, there are areas where the general counsels would need support on from law firms, from experts in the area, from people like you, on areas that have been newly introduced into the new codes, their definition, the way it will be implemented, those are areas, the way it will be enforced are the areas where the focus will be in terms of compliance.
Thank you.
So, coming from what I was saying, Anil, just now, I would like to put across a question to you. Since you've worked with GCs for a long time now on this subject matter, uh, can you briefly explain the concept of floor wages, which is the talk of the town as of today, and also the role in minimum wage fixation and their impact on multinational companies as on date in terms of the new code that we have?
Thank you, Tripti ma'am, for the question. In fact, this is very pertinent because I think there is a lot of confusion with respect to the concept of the floor wage. So, this is something new which has been introduced by the Code of Wages. It was not there in the earlier Minimum Wages Act. So, floor wage is the national rate prescribed by the national central government, below which no state can fix their minimum rates of wages. Now, this is very important to note that employers are directly not concerned with as to what is the floor rate, because it's a directive which will be issued by the central government to the state government to keep their minimum rates of wages either at par with the floor wage or above the floor wage. So employers are not directly concerned with the concept of floor wage. I mean, in terms of compliance and execution, the states will have to follow the directive of the central government, and they are mandated by the act to keep their minimum rates of wages either at par at above the floor wages. Now there are multiple factors that determine the fixation of the minimum rates of wages. I mean, consumer price index, the region. I mean, it will be different for tier 1 cities, it will be different for tier 2 cities, for the rural areas, then region wise also. For plains it will be different, for hilly areas it will be different. So states determine the minimum rates of wages uh, for the subject matters which are falling in the state list, while central government still continues to determine the minimum rates of wages for the subject matter which are falling under the center. So for the PSUs, even if they are operating in the central PSUs, even if they are operating in a particular state, the the minimum rates of wages determined by the central government would continue to be applicable to that PSU, which is under the central government. Similarly, the entities which are operating in a state field, they will be governed by the minimum rates of wages determined by that particular state. Another aspect which is important to note here, that both the minimum rates of wages and the floor wages, as per the provision in the codes of wages, they are to be revised in every 5 years. Uh, for minimum rates of wages, there is a provision to, I mean, revise it in interim revision can be taken in 6 month time also, like 1st of April and 1st of October in 6 month duration. So
Just
just,
I will clarify
yeah, please,
that
sir.
this revision is not an interim, rather the DA will be uh, fixed, and after a gap of 6 months, first in the first of April and another on the 1st of October. So there is no any basic change in the minimum wages, rather there will be the changes in the dearness allowance, and both the central and state government will vary. Now continue.
Absolutely, absolutely right, sir. Keeping in mind the consumer price
Yeah.
index, right?
Yes.
So, as sir mentioned, the interim variations can happen in 6 month gap duration. So, what I want to summarize here is that there is a lot of misnomer uh, um, eh, uh, 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 regarding the national minimum wages. So there is no concept as such of the national minimum wages. It's a floor rate which is determined by the central government, and the employers per se or the employees per se are not directly concerned with that concept of floor wage. So this is one thing I want. Now, what is the impact of the new provision on the minimum rates of wages on the companies which are operating across jurisdictions in different states? So one thing which comes straight to my mind, as sir mentioned, that this provision of 50% wage, I mean, we all know that the statutory deductions, whether it is PF or ESI or gratuity, this cannot go beyond 50%. If it goes beyond 50%, then it becomes a part of the wage. So that way, my presumption is that this is going to increase the cost on the employees to the companies by at least 8 to 10%. So that is one impact which the GCs and the companies have to watch out for while uh, uh, taking a costing structure for their respective companies. The other impact which this code on wages brings on the companies is the very clear cut definition of the or very clear cut outlining of the concept of principal employer's liability. Although this concept was there earlier also in the Contract Labor Act, but now it has been given a very clear cut provision in the Code on Wages itself, that the liability for the payment of wages is primarily is the joint and several of the principal employer along with the contractor. So earlier a shield was available to the principal employer that I mean, the employees or the worker is the employee of the contractor. They have to ensure their timely payment. They have to take care of their statutory deduction and all. Now that concept is gone. So now it is the responsibility of the principal employer. In fact, they have to supervise it to ensure that there is no underpayment to the employees. They are given payment on time. All the deductions are done on time. So this is one sphere where the GCs and the companies have now to be more alert, and they have to be more proactive to ensure that all this is done by their contractors if it is through third party contractor. Another impact that the code on wages brings is with respect to the fixed term employment. Now, as per the new codes on wages, even a fixed term contract employee, if he has completed 1 year with the 1 year of employment, he is entitled for gratuity. So that costing has to be kept in mind while provisioning a budget for on the cost of the employees. So that is another area to look out for and factor. So I think that's sums up the
Yeah.
concept of floor wage and the minimum wages and the impact on the companies. Now I would like to go to Nayan.
Means you want to say that if the companies are coming into our country, companies are coming into our country, then they have to taken care of all these factors.
Absolutely,
That
sir.
that the
Absolutely.
principal employer has to be vigilant that the minimum wages are being paid to the contract levels. And
Absolutely.
if it is not, then it becomes the responsibility on the principal employer. If the contractor is not giving the minimum wages, then it becomes the responsibility of the principal employer, and the principal employer will decide how to recover this
Recover it from the
amount
contractor.
from the
Absolutely.
contractor.
Absolutely, sir.
Means these are the factors, these are the things which is to be taken into account. These are keep in the mind of the companies who are
Right.
coming to India.
Yes, sir.
So basically, the
In the
burden cannot be shifted. The principal
Absolutely.
employer will always remain responsible for these
Yes.
Yes.
compliances.
Yes. Okay. Thank you.
Thank you, Anil.
Thank you. So now I'll turn up to Nayan for a very important concept of overtime, because this has been a bone of contention. In fact, I have handled many litigation where overtime issue has been there. We have fought it out before CGIT and state industrial tribunals. So Nayan, now that the concept of scheduled employment has been done away with, and the overtime, I think section 41 it is
14, sir.
14, section
Yes,
14
of code on wages.
yeah, code on wages has this provision relating to overtime. So can you explain, I mean, what are the category of employees who are entitled for overtime, and what impact it will have on the wages overall from the company's perspective? So Nayan, could you briefly explain the concept of overtime as provided in section 14 of the code on wages, and uh, its impact on revised definition of wages under section 2Y of the codes on wages?
Thank you so much, Anil sir. I think you've asked me a really straightforward question given my age, probably, but I try to answer it in the best possible manner that I know. Section 14 of the code on wages, it talks about how overtime is to be dealt. So I would want to specify a particular expression that has been used. Overtime is applicable where minimum pay has been fixed under the code. This expression has to be taken note of, that where minimum pay has to be fixed under the code. Now, many employers, they are under the impression that overtime payment is applicable universally to all. Even sir touched upon that it's universal application, but that has to be borne in mind that where the minimum pay has been fixed under the code, then only the provisions of overtime they run in. Now, the next question that anyone would ask where you would find this minimum pay fixed under the code, though that is provided under the rules under Schedule E of the draft Code on Wages rule, which are yet to be enforced. Now, earlier overtime employment was a compartmentalized concept. It was governed by the Minimum Wages Act, wherein only the categories of employees that were there in the scheduled employees category, only on those the concept of overtime payment applied. Now, with the advent of time, it was seen that the scheduled employees needed revision, constant revival in order to cater to the needs of the changing time and tides. And obviously, you cannot discriminate against one particular set of individuals who are entitled to overtime against those who should be entitled to overtime, but they are not provided the basic minimum overtime allowances. So obviously, a lot of constitutional aspects also figure into that. And in order to cater to this particular situation, this particular provision was brought in. Now, the strategies that an employer should adopt in order to comply with this overtime is very subjective, because every HR policy, every compliance manual, it is a very intrinsic concept, and it differs from company to company. So, a company can do a comprehensive annual audit. They should do monthly audits. They should do quarterly audits based on their budget and based on the resources that they have. Now, a very pertinent aspect of your question, Anil sir, that you asked is how this concept has to be linked to the wages definition. Now, wages definition is the talk of the town when you talk about labor codes. So, overtime, so to say, has to be read in consonance with this particular definition. Earlier, what used to happen was 50% uh, 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 the overtime as a concept is twice your normal wages. That has remained constant. However, the definition of wages in itself has changed. Earlier, on the basic pay, overtime allowances were provided. Now there is an excluded category. So if that excluded category on the right hand side, it exceeds your 50% on the left hand side, which includes your basic pay, your dearness allowance, and your retention allowance, then that 50% has to be brought back and added back to the definition of wages, and twice has to be paid uh, on that particular calculation. So that's how there would be an increase in the overtime allowances that was not there earlier. So in order to sum up, there are two important aspects that need to be taken care of. First is this calculation aspect, that it might increase because of the change definition of wages, and second, that now the companies or the employers, they cannot bypass the applicability of the overtime allowances, wherein earlier there were categories that were there on which overtime applied. Now it is rather universal, but it has to be read in the specific language of the code, which clearly states that where the minimum wages are fixed under the code, and this minimum fixation is as per the schedule under the draft rules.
In this, Nan, I will like to add one more thing.
Yes.
That is, the minimum wages is applicable when any worker is working for, or any employee is working for more than the normal working hour in a day.
Right.
And there is a confusion that the normal working hour is a 8 hours a day or a 9 hours a day. But I'll specify that it is 8 hours a day, and when it is said that it is a 9 hours a day, this is inclusive of the lunch break as well as the other tea breaks and the rest also during the day. So any worker who is working for 8 and plus hours a day, excluding that lunch hours, if he is working for more than 8 hours a day, he will be entitled for the overtime. And the rate of overtime, as the Nayan said, that it is the twice of the normal wages. And of course, since the definition of the wages has been changed, so automatically the overtime will also increase. So any company who is coming in India and liable and wanted to comply the provisions of the labor law, they have to take into account that this the overtime liability of overtime will also increase.
So what I understand from here, sir, is that earlier also some of the companies, most of the companies, multinational companies, were already taking care of this particular, uh, you know, payment of overtime. It's just that now the companies who are trying to bypass will find it a little difficult to really evade this particular compliance, is what how I understand.
Yes.
Otherwise, I don't think there's much that has changed, right?
That's true.
Yes.
Very brilliantly put, Abhijeet sir. We always look up to you when there is requirement for any clarifications, because you being the subject matter expert on this particular aspect. Now,
Thank you.
sir, there's a very pertinent question which all the employers would want to know an answer of, is with respect to non-compliance. And in order to cater to this aspect, a new concept called inspector cum facilitator has been introduced under the labor codes. Now, this word comprises of two words individually, which is inspector and facilitator. I would like to know your inputs, how this inspector and how this facilitator has to be perceived under the new labor codes.
Then I'll attract your attention towards the principle of the International Labour Organization, which is continuously emphasizing that the motto of the government should not be to prosecute the employer for its negative steps.
Right.
If they fail to comply the provisions of the labor law, they should be helped how to comply, and no deterrent action for filing a prosecution against them should be initiated. So they should be given an opportunity. So the compliance should be the main objective of the government, not the prosecution should be the objective of the government. And with this view, the government has introduced the term of inspector cum facilitator. Inspector means he has been given the responsibility to ensure that the provisions of the law are being complied, and the facilitator means where the employer fails, then the inspector should be there to help him, to assist him how to comply the provision. That's why this both the words have been brought together to make a new rule of the inspector cum facilitator, that not only to prosecute but to assist the employer. And this is I'll also say that there is no any basic change except the assistance part. No other changes has been brought, because earlier also the inspector were given the powers of civil code, which empowered them to enjoy the powers which is given to the civil code. So the same provision has been continued, and but except this, that they have to assist them, and by during in the process of assisting them, it is necessary that the employer should be given one opportunity. And that's why the government has also introduced that there will be a provision of inquiry officer who will be the authority from the labor department. Both the appropriate government will appoint their inquiry officer, and for all those irregularity, all those offences which are petty in nature, means where the uh, fine is less than 2000 rupees and the imprisonment is less than 2 years, the power has been given to the authorities from the labor department that they will inquire into the matter, and they will have the liberty, they will given the opportunity, they have been given the power to examine that can it be is there any possibility that the employer can be assisted to comply the provision. Otherwise, the judicial authorities, the courts were not given such a power that they can, in every case where the prosecution is filed before the court, criminal courts or the judicial magistrate, the fine was evident.
Right.
Means though no employer could escape from this, but the intention of giving the inquiry officer or the provision to bring the inquiry officer or to create a post of the inquiry officer is more or less uh, discloses the intention of the government that employer should be given more opportunity to comply the provisions of the law, and in the similar way the word facilitator has been attached with the name of inspector.
Pretty fascinating, sir. So, can we say that it is somewhere intertwined with the concept of principles of natural justice? That in the broader umbrella of principles of natural justice, this particular concept has been introduced.
No, not that. It is not a new concept. The principle of natural justice was earlier too. When the inspector played the role of the inspector, or under the old labor laws or under the new labor codes, he has to stick by the principle of the natural justice. Without adhering to the principle of natural justice, no inspector or no any authority can take a direct action to against an accused. So this is not a new principle. This has been taken from section 14 of the Indian Constitution. So this is not a new, this is the old provision, except this, that under the new code, the provision has been incorporated that in case of the uh, non-compliance, first violation of the provision of the labor code, he will be given, or there is a big chances of given opportunity that he will be saved from the prosecution.
Right.
But under the in the second time or in the subsequent offense, there is the possibility is very less. So the principle of natural justice was earlier too, and it will be continuing. And one more thing I will add, that the new provision of compounding has been introduced. New provision of compounding of offense has also been introduced with the same intention, that the employer should be given the right to given an opportunity to rectify their irregularity if they don't want to go to the courts and want to dispose of the matter before the authority. So there is a provision that the officers from the labor department will be appointed as the compounding officer who has been given the right to compound the offense. So these are the, in nutshell, shows the intention of the government, intention of the code, that maximum help can be given to the employers for complying the provisions of the labor.
Thank you, sir. Sir, if I may ask, considering you come from a government side of drafting this particular code and also its enforcement, uh, what is that one thing or one take that you think is the most important provision in the whole code that the general counsel or a company, rather a directors of a company, should address within a short span of time, or in the next quarter, or in the next 2 months, and they should be ready with it? What is that one most important element?
In my opinion, the change in the definition of wages is the most important thing, which every HR or the legal counsel should advise to their employers, that they should restructure their pay scale, restructure their salary scale, because once the rules on the of the code on wages will be introduced, which is expected to be in the next month by May 2026. Once it will be implemented, the other authority will visit, and in my opinion, the most crucial thing, or the most important challenge which they have to face, is the provision of the provident fund, provisions of the gratuity, provisions of the overtime, and provisions of the earn leave, encashment of the earn leave. Because all these four provisions are based on the revised wages, and there will be a additional financial liability on the employer So every general counsel should take into account and should advise their employer, honest advice to their employers, that they should as early as possible they should restructure their salary scale.
Thank you, sir. So, viewers, we are coming to a close on this particular episode of the podcast. Of course, it's a new legislation. There will be teething issues, and we'll come up with more such episodes to clarify on the legislation as the rules also comes in place by the states. That would be a time to revisit, and we are really thankful for the chief guest that we have over here for being part of this particular podcast, where he has really helped us understand the basics of how things needs to be taken care of. And also thanks to Anil and Nayan for being part of this podcast. Thank you very much.
Thank you.
Thank you.
Thank you.
And with that, we come to the end of this episode. Thank you for tuning in, and a big thank you to our guest for those valuable insights. If you enjoyed this, don't forget to subscribe, like, and share our channel Hammurabi and Solomon with the legal minds in your network. We'll be back soon with more such conversations. Thank you.